Thank you very much. This panel will closely relate to the topic discussed during panel 1. If some questions remained unanswered, we will have enough time to address them during the discussion within panel 2. This panel will discuss the future of dealing with the past. It's rather complex. We will talk about the process of dealing with the past in the future period after the ICTY has finalized its operations and after national judiciaries continue with the effort to facilitate the dealing with the past, and so that because it influenced the establishment of facts and the processes of dealing with the past in other countries where conflicts occurred. We deal with that every day, people sitting in this conference room. Those processes within the broader context are in their initial phase. So during this panel, the panelists will discuss the issues and the activities that can contribute to this process, including the activists, and we will probably address the issues raised in panel 1 as to whether we can do better than this. Together today with us is Mr. Martin Petrov, the Chief Immediate Officer of the Registrar of the ICTY, Ibro Bulić, the Prosecutor of the BIH Prosecutor's Office, Mrs. Nidžara Ahmetašević, journalist, Dr. Goran Šimić, the Professor and member of the Expert Group on Bosnia's Transitional Justice Strategy, Bosnia and Herzegovina, and Mr. Dino Mustafić, Film and Theater Director. Mr. Petrov, we will start with you. You are here representing the ICTY. The mandate of the ICTY will soon end. And what do you think will happen in future in terms of these processes that we mentioned and dealing with the past?
Thank you, Aleksandra. Good morning, everyone. It is actually a pleasure for me to be here and to address you today on in the framework of this particular panel. Dealing with the past beyond the tribunal, and to share some of the most recent institutional developments which will be very relevant to that topic. We've heard in the panel just before this that there have been many expectations about the things that the ICTY could have done and should have done better, and we've heard a lot of disappointment in terms of what the tribunal didn't achieve, according to some. I think it's very important to remember that the tribunal was never intended to be a panacea and to resolve all the problems that arose as a result of the conflict in the former Yugoslavia. The tribunal has a very specific, discrete mandate, and importantly, it has always been intended as a temporary institution, one which would try the most serious perpetrators of war crimes in the region of the former Yugoslavia, and then would close its doors, giving and leaving essentially the space for national prosecutions, for such crimes to be prosecuted at the state level in all the states of the former Yugoslavia. And this is what I'd like to touch upon today. As most of you have heard, the residual mechanism for international tribunals has been established. This is how the Security Council has provided an institutional platform to continue the work of the ICTY, which will enable national jurisdictions to continue prosecuting and trying war crimes cases. The institutional development that I'd like to share some views about is relatively new. The mechanism was established in 2010, in December 2010, and it will continue the main the essential functions of the ICTY and its sister tribunal, the Tribunal for Rwanda. This obviously doesn't come as a surprise, this development, because it is clear that once the tribunals, and in particular the ICTY, no longer exists, there are a number of functions that need to continue being carried out, and including, very importantly, the assistance provided to national jurisdictions. As such, the two tribunals worked closely with the Security Council of the United Nations, and there is now this new body, which many of you have heard about, but I don't know how many of you actually know what it is about, that has already been established on the 1st of July 2012, sorry. Very briefly, it is a body that will be a single institution, but with two branches, one for the ICTY, which will commence on the 1st of July 2013, and its seat will be in The Hague, and one for Rwanda, for the Tribunal for Rwanda, I'm sorry, and it is, its seat is in Arusha. The tribunal, the mechanisms branch in Arusha actually opened on the 1st of July 2012. In terms of its structure, it will be very similar to the ICTY in the sense that it has one president, one prosecutor, and one registrar. But at the same time, it is going to be a very small and efficient organization, which will also be temporary, the same way as the ICTY was a temporary institution. What are the main characteristics of the mechanism? First of all, we shouldn't be looking at the mechanism as a mini ICTY, because as I mentioned, the mechanism only has the mandate to carry forward or to carry out the essential functions of the tribunal, and I'll come back to that in a second. In addition to that, it is going to be a temporary institution which will be assessed, the need for it will be assessed every 2 years. And importantly, as I mentioned, the mechanism will commence its operations while the tribunal is still in existence. So for a period of time, the tribunal and the mechanism will coexist, but in a way that only one of them, only one of the institutions will actually have jurisdiction to deal with a certain matter. And importantly, for most of you, the Security Council has decided that states shall make arrangements to take all the necessary measures to implement the statute of the mechanism in their respective national legislations. Turning now to the functions very briefly, those essential functions. There are some purely judicial functions that the mechanism will carry out, and they include the trial of fugitives. For the ICTY, obviously, that's no longer relevant because of the fact that all our fugitives have been apprehended and are currently on trial. Appeals against ICTY judgments. The important date to remember here is that any notice of appeal filed after the 1st of July 2013 will mean that the mechanism and not the ICTY will have jurisdiction to deal with that appeal. Retrials of persons indicted by the ICTY. Again, the cutoff date is the 1st of July 2013. If there is a retrial ordered after the 1st of July, then the mechanism will try that individual and not the ICTY anymore. The same goes for review of final judgments. If such an application for review is filed after the 1st of July 2013, then the mechanism and not the ICTY will deal with these review proceedings. And finally, referral of cases in terms of the purely judicial responsibilities of the mechanism. Of course, for the ICTY, as you are aware, all our cases have now commenced, so none of them is considered at present for referral. In addition to those purely judicial functions, however, there are a number of very important functions which I guess would be of the biggest significance to you. The protection of witnesses. Obviously, the protection of witnesses doesn't end with the closure of the ICTY. The need to protect witnesses, that is. And that includes not only maintaining existing protective measures, but also responding to requests to vary or rescind such protective measures in order to use such evidence, for example, in national trials. the ICTY will only remain in charge of such protective measures for cases that are ongoing before it until their completion. All the other cases, protection of witnesses in completed cases, will be in the hands of the mechanism as of the 1st of July 2013. Another important point, the supervision of the enforcement of sentences. As you know, the ICTY has agreements with several states for the enforcement of sentences, and the president of the ICTY is responsible for the supervision of these sentences. On the 1st of July, that jurisdiction passes on to the president of the mechanism, so as to say that from the 1st of July onwards, any requests, 1st of July 2013 onwards, any request for early release, for example, or commutation of sentence will be dealt with by the mechanism and not by the ICTY. The other two, the last two functions, are the assistance to national jurisdictions, and that has to do with the provision of evidence that is necessary for national trials, making persons under the authority, arrested and being under the authority of the tribunal available to testify in cases before national jurisdictions and similar. On the 1st of July 2013, again, that important date, that power will be with the mechanism and no longer with the tribunal. And finally, a topic that was touched upon this morning, the management of the archives of the tribunal. The Security Council has decided that the archives of the tribunal will be collocated with the mechanism, which means that, at least for the time being, there is no doubt that the mechanism will have the power to manage these archives, to preserve them, to secure access to them for the countries of the former Yugoslavia and the public at large. What does it mean in practice? In practice, it means that as of the 1st of July next year, the mechanism will be your point of contact for all these issues that I've just mentioned. It essentially means that these functions, which are currently ICTY functions, will move on to the mechanism, and the mechanism will have the sole authority to deal with them. That is a very important change to realize and to recognize, because these residual functions that I've mentioned will be how the Security Council will continue, or the mechanism rather, that the Security Council has put in place to continue assisting the process of dealing with war crimes and those atrocities in the region of the former Yugoslavia. In other words, the mechanism will be there to assist national jurisdictions to carry out that work. It is, and this is really the last thing I'm going to say, the Security Council actually specifically recognized the need to have such a mechanism in place for that very purpose, to continue the work that the ICTY has started by enabling the national jurisdictions of the countries of the former Yugoslavia to continue that work. Let me actually stop at this for now. Yeah.
Thank you, Mr. Petrov. Considering the context, without any further delay, I will give the floor to Mr. Ibro Bulić from the Prosecutor's Office of Bosnia and Herzegovina. Ladies and gentlemen, allow me to express my gratitude and to also extend the gratitude on behalf of the Prosecutor's Office of Bosnia and Herzegovina for inviting us to attend this very important conference. For a number of years, the Prosecutor's Office of Bosnia and Herzegovina has received reports about the persons suspected of committing criminal offenses. All of these reports required a thorough analysis before indicting these persons. These are very lengthy proceedings that often required several years because prosecutors search for evidence to prove each fact beyond reasonable doubt in order to ensure fairness and justice. The victims exert continual pressure to expedite the proceedings and have the perpetrators punished, which is understandable. In Bosnia and Herzegovina, we must create the atmosphere in which persons who committed crimes will not be considered as national heroes, the atmosphere in which persons can testify before courts without any fear. There has to be support to witnesses to come to court and testify without fearing retaliation. Building trust between people, other factors must be included, not only judiciary, non-governmental organizations, and other social sectors. The establishment of the Prosecutors Office of BIH and the Court of BIH, which started operating in full capacity in 2005, marked the shift towards the prosecution of war crimes. We are prosecuting war crimes respecting, while adhering to the standards and respect of human rights. The national strategy for prosecution of war crimes deals with all the problems that might prevent efficient prosecution of war crimes. The courts and the prosecutors' offices in the Federation of Bosnia and Herzegovina and the Republika Srpska and the Brčko district have also contributed significantly to investigations and trials in less complex and less sensitive war crime cases. Despite these positive movements and developments in trying war crimes, there is a series of problems that prevent better efficiency, greater efficiency in the prosecution of war crimes, such as very complex legislation in Bosnia and Herzegovina, of which my colleague Judge Vucinic talked about earlier this morning. The key mechanism for the implementation of the national strategy is referral of smaller cases to the entity jurisdictions, which will enable the court and the prosecutors of BIH to dedicate their resources to the most complex of cases. Administration of justice takes time because perpetrators who were holding key positions in the military or in the police were already in their mature age, and many of them are no longer alive. The same applies to witnesses who had passed away in the meantime or are now residing in different countries of the world. Even when you have a perfectly functioning system, judicial system, the national and ethnic tensions in Bosnia and Herzegovina can contaminate the judiciary and obstruct its efficiency. There is a lack of political support to prosecution of war crimes in Bosnia and Herzegovina coming from certain circles, which is obvious in the campaigns attacking judicial institutions, interfering with the cases and undermining the reform of judiciary, and in denying war crimes that had been established in final decisions. There is a lack of trust despite these efficient reforms, and all this creates a negative impression in the public and prevents the judiciary from adequately responding and working efficiently and communicating efficiently with the public. The prosecutor's office and the court had international members, including international prosecutors, judges, investigators, persons working with the witness support section, and other professionals. They shared their valuable experience with our national prosecutors and judges. The witness support section and is offering support to and protection, offering support and assistance to the witnesses. As for the ICTY, it is important to emphasize that the ICTY has prosecuted the top-ranking political, civil, military officials, senior officials, and generals who held the highest positions, who were issuing orders and were making decisions. The ICTY has been working on establishing contacts with different stakeholders in the national jurisdictions in the countries of former Yugoslavia. OSCE has extended adequate support, and other organizations interested in strengthening local capacities dealing with the international humanitarian law. The contacts between national experts and their international colleagues, and between international and national experts in judicial systems in general, have offered them the opportunity to share experience, which should be done in future. Opening up towards the society is crucial for a better understanding, and will help different groups in understanding the events that had taken place. Without adequate access to information about the events that took place during the war only leads to speculation and misunderstanding. International humanitarian law is an extensive legal body, and it is developed before the courts of different countries, international tribunals such as International Military Court in Nuremberg and the Hague Tribunal as well. The legal standards are now made part of the legislation, criminal legislation in Bosnia and Herzegovina, which will ensure the protection of human rights in the territory of the entire Bosnia and Herzegovina.
The application of the current criminal code of Bosnia and Herzegovina is in accordance with the general criminal policy of the ICTY, where crimes can be punished even if they are not specifically defined in the law that was in force at the time of commission, if the accused was aware of his acts at the time of the commission, as well as the consequences of the acts, such as crimes against humanity. The jurisprudence of the Court of Bosnia and Herzegovina and national courts dealing with war crimes cases rely substantively on the jurisprudence and standards of evidence of the ICTY, including, for example, command responsibility, which is a mode of responsibility where the superior is responsible for the crimes of his subordinates if he failed to prevent them or punish them, unlike the crimes that he ordered. The command responsibility doctrine was made part of the additional protocol to the Geneva Convention pertaining to international armed conflicts. The jurisprudence of the ICTY also established the standards for JCE as a mode of guilt, appearing in 3 different forms. Judge Vucinic also spoke about that. And to wrap up my presentation, since Judge Vucinic elaborated on this, I will not go into details on the JCE, as well as the issue of established facts originating from the final judgments of the ICTY, which are a valuable instrument of evidence for prosecutors in Bosnia and Herzegovina, and that are used in the practice before the national courts ever so often. Also, standards of proof for crimes against humanity and crimes against international law will also be used in practice, together with the notions of command responsibility, JCE, persecution, widespread and systematic attack, unlawful attack on civilians, ethnic cleansing, the nature of armed conflicts, discriminatory intent, sexual abuse, etc. There are many standards applied and taken over, adopted by the courts in Bosnia and Herzegovina, originating from the ICTY. Prosecutors in Bosnia and Herzegovina also have access to databases of the ICTY, which are a rich source of information and evidence. The only problem is that many prosecutors still do not have the password to access the database. I hope that this issue will be resolved in the future. Allow me to tell you something about problems that prosecutors in Bosnia and Herzegovina face in their everyday work regarding the cooperation with the ICTY. Prosecutors' offices have problems with the use of evidence, namely witnesses that testified under protective measures before the ICTY. The use of such transcripts is limited once they are translated into official languages of Bosnia and Herzegovina. They are not considered relevant unless the witnesses appear for cross-examination. Not enough has been done to date in terms of witnesses who were awarded protective measures. They have to give their consent for the use of transcripts before national courts. Many of them refuse such consent, and this issue has to be resolved. notes, records of the ICTY, especially records from closed sessions, are potential problems because they contain the names of potential suspects or the names of potential witnesses or certain facts relevant for the prosecution of cases here. There will be a huge body of documentary evidence left after the closure of the tribunal, and we believe that the Court of Bosnia and Herzegovina should be the venue where all these documents will be kept in future. There are several arguments in support of that proposal, but due to limited time, I will not go into further details. Thank you, Mr. Bulić. I'm sure you will have the opportunity to talk more during the discussion. ICTY, as well as the courts in the region and courts in Bosnia and Herzegovina, have a very important role in the establishment of facts and dealing with the past. What we see in everyday life is that the dealing with the past is not dependent exclusively on the courts in practice. I'm sure Nidžara Ahmetašević, a journalist, can tell us something about the role of the media in this process. Thank you, Aleksandra. Good afternoon. I see the role of the media as very important, actually the most important after the courts, because it is very difficult for the members of the general public to gain access to information about what's going on in the courtrooms if the media do not cover the trials sufficiently. The role of the media is frequently disregarded by judges and prosecutors. They find it difficult to appreciate the role of the media as a channel to direct information about the trials. Also, political structures present a problem. We have seen many examples where politicians used information about trials and verdicts for their own hidden agendas and for their propaganda. We know that in the region, politicians are still in close contact with the media. Many media here and in the region, I believe, are under direct control of certain political structures. And when such media report on the trial or the proceedings, they usually write what they are told to. So 20 years since the beginning of the war and so many years since the end of the war, so many years into the existence of the tribunal and the Court of Bosnia and Herzegovina, we are frequently in the position to hear the politicians say paroles, denial of verdicts and court decisions, and it is difficult to distance ourselves from such influence for as long as the role of the media is neglected. I know it is very difficult for judges and prosecutors to work with journalists, and that's how it's supposed to be in many cases. However, when it comes to war crimes, judicial officials have to be more open towards the media. Our judges had a very important lesson to learn from the ICTY. I'm afraid that they failed to learn that lesson. The tribunal worked for 5 or 6 years on its visibility strategy, on opening up to the public. Here, however, we had problems with communicating with the judicial institutions. Judges and other officials giving limited information to the media in a way contributed to the political euphoria created through certain media in this country. As of recently, we've seen the enactment of certain laws limiting the activities of the media in covering war crimes trials. That makes our job difficult. I don't think it helps the court or the prosecutor's office much. The journalists will find their way, or they will simply abandon the coverage, and the politicians will profit from that, while the public will be at loss. I believe this is a very important question, and I believe that the courts and the non-governmental sector that is also frequently unaware of the role of the journalists have to open up more, and the journalists, on the other hand, have to maintain their professional standards. As much information they have, the more the greater will be their professionalism and ability to defend themselves from the political pressure, and we will have at least one part of the media community breaking through all the obstacles that force us to talk about us and them, and that force us to forget that war criminals are individuals with their last and first name, as well as the victims. Thank you. Thank you, Nidžara. What other mechanisms do we have to see in Bosnia and Herzegovina in addition to war crimes trials? Professor Goran Šimić. Thank you. Allow me to welcome you, ladies and gentlemen. I will try to summarize my points. A lot of it has already been said. Being involved in the transitional justice, I would like to start by giving my own opinion on the 20 years of the tribunal, which in a way follows up on the previous discussion. I don't think that the ICTY is a perfect tribunal, not at all. I also don't think that everything they did was great and perfect. I don't think that the world would be a better place without the ICTY. Do I think that we have to drop public transportation and cars simply because they pollute the environment? No, I don't. So we have to bear in mind that the ICTY started from a clean cut, from zero, from nothing. And if we are to believe what Carla Del Ponte says in her book, it is a tribunal for which many wanted never to come into existence. We have to be aware of another thing. How much did we contribute to the work of the tribunal, or how much did we make the work of the tribunal more difficult? I believe we will realize that we did much less in terms of contribution. We also have to be honest and say that the ICTY set up very important foundations for the establishment of other courts and tribunals. I don't think that victims are only direct victims of crimes. I believe that we are all victims here, all of us living in the area of the former Yugoslavia. We are all victims of what happened to us in the 90s. Citizens of Bosnia and Herzegovina are a special category of those victims because the past is on our way, obstructing our way to the future. We are living in a country where the past still keeps us in shackles. Without the tribunal, it would have been very difficult for us to face our past, to see all the political, military, and civil leaders before the court, facing their responsibility for what had happened. Do we need more than the courts? I am a lawyer, and maybe I will say something sacrilegious for lawyers in the next couple of minutes, but I don't think that courts alone are sufficient. I think that Bosnia and Herzegovina, just as any other country of the world, and as you can see, there are dozens, hundreds of places in the world today where people are suffering equally as we did, or even worse. All those countries, including ours, need courts. However, I am convinced, and I believe you will agree with me, that the work of the ICTY over the past 20 years has showed us that trials are not sufficient. Trials will not raise monuments. Courts will not identify each and every victim by their name. Courts will deal with cases brought before them, but not all potential cases. If you analyze the Criminal Procedure Code of Bosnia and Herzegovina, you will realize that the court will not establish the truth, but the state of facts to determine the criminal liability of an individual. I'm glad to have heard this from the Vice President of the ICTY, that the ICTY has never created a foundation for redress and reparation of victims. The courts will not name the streets or raise the monuments or deal with the names. In Bosnia and Herzegovina, there are 4 serious flaws that we have to remove if we want to have fair trials for everyone. First of all, I believe that here we have an incredible situation preventing serious work. And it seems incredible to me that we still don't have a sound legal framework, statutory framework for the work of our courts. The Court of Bosnia and Herzegovina operates under one code. The entity courts operate under another code. What we have is chaotic. I believe this is absurd of its own, and it undermines the social effort to establish the accountability of everyone involved. On the other hand, everyone brought before the court has the right to a fair trial regardless of what he is suspected of having done. Then, punitive policies. I don't think that 6 years in prison should be replaced with 20 years. I don't think that that would achieve much. I'm glad that the Vice President of the Tribunal is here. I believe that the international community should consider expanding the punitive policies. Prison sentence is inadequate to sanction someone who killed whole families, who raped girls, who took part in atrocities. 600 years would be insufficient. Why? Because the victim is not recognized there. My main objection, so to say, to the ICTY and to all other courts, national courts, is that the victims are marginalized. We are here not because we are perpetrators, but because we are victims. Victims are those who generated the talk about what happened and considerations of guilt and responsibility. Criminal Procedure Code of Bosnia and Herzegovina, out of some 400 articles, refers to a perpetrator and his rights in 90% of those. He has the right to presumption of innocence, for example. He has the right to a fair trial, right to defense counsel, right to communication, right to this, right to that, right, which is fine. But let us consider this from the victim's perspective. Let us consider the number of articles referring to victims and their rights. I believe you will stop counting very soon because victims are mentioned only in terms of property claims, and I would like to hear an example where any such property claim was brought to a conclusion and actual redress. I believe that the focus should be on the victims. It is the victims that we are here for. And I would like to say one other thing before my time expires. Plea bargaining is a huge issue in Bosnia and Herzegovina. It is a very useful instrument. However, in the war crimes cases, it is highly questionable. As I mentioned, establish the truth. Trials are fine, but we need the truth. Society is not built on trials only. It is built on the justice and truth. Truth and justice for all victims, not Serb, Bosniak, and Croat and other victims, but for all victims. Without that, we will see no progress. What else can we do in addition to trials? Over the past 10 to 15 years, it became quite clear that trials are insufficient. Trials, of course, are a great thing. They determine a certain segment of the truth. They determine the position of the criminal and the victim. However, they do not lead to reparation, to reform of institutions, to vetting of officials, to school lessons, to history books, to rehabilitation of victims of PTSD, and so on. In future, in Bosnia and Herzegovina, I hope we will recognize the importance of other mechanisms and other activities often referred to as transitional justice, dealing with the past and so on. Other processes that will enable all Bosnian citizens, regardless of their ethnicity and religion, to find satisfaction, to find redress and reparation for what they have suffered. Without that, I believe that the future is uncertain. If you have a look at the history of Bosnia and Herzegovina, you can see that for quite some time already, we frequently refer to historical events. What happened between 92 and 95 was not random. There was a number of factors that led to that, but the courts will not deal with it. Other mechanisms should deal with it. There is a need for a new category. Other mechanisms of transitional justice, which would include reparation, restitution, institutional reform, and a forum for victims where we will keep their stories and their voices for posterity. Thank you. Thank you, Mr. Šimić. Certain activities have been undertaken to deal with the past of Bosnia and Herzegovina. We can see that in our theater and films. Mr. Dino Mustafić, thank you for inviting me and allowing me to speak on behalf of the artists that certainly bear their share of responsibility for the future and the past. Since I come from an emotional sphere, valuing life as the most important in the global order of things, I will talk about what my colleagues and I do for progress, for good, for reconciliation and acknowledgement of truth. In that regard, we have to recognize that past comes back from the future. We should not neglect future. I know we are all bothered by our past. I know that the past here is most frequently used for ethnocentric perspectives on history, that arguments are mainly historic and used for daily political agendas. I know that writing history is always characterized by overall innocence and everyone's the victim of the other one. But that is not the road to historical memory, that will not see facts as relative categories and that will not falsify our history. The only way for us to comprehend the role of individuals and of institutions in the horror that happened in the former Yugoslavia was to stop manipulating with the facts, to stop celebrating criminals as our heroes, to fight against collective amnesia and nurtured oblivion, and to act with responsibility for the future generations. Literary works, films, theater plays represented a creative memory and liberation from the past of blood and anxiety. And such works, acting in a humane way to capture the perspective of an individual victim, pass through the walls of hatred, awoken contrition and compassion. In that regard, I believe that the artistic community in Bosnia and Herzegovina has its battles to fight. What always concerned me as a human being, as a father, as someone who survived the siege of Sarajevo, as a human being, was
ljudsku čast.
Indifference towards human tragedy. I know I am one of the rare, fortunate people who has not lost a loved one. I know it is difficult to live through a personal tragedy and forget and forgive. I know that people here will not be able to forget, but they will have to forgive. That is our moral priority. And that is why the victims in this war bear the greatest responsibility of us all. They will carry the heaviest burden of forgiveness. It is up to us to take notice of each tear shed, of each drop of blood spilt, of each person lost. That is how we will maintain our respect towards people, regardless of their ethnicity and religion and any other category. That is what will make us aware of what we've been through and what lies ahead. That is why it is not human, it is not ethical to draw differences between victims as if some victims were entitled to more than others. All victims deserve equal amount of respect. However, to consider victims equal does not mean to draw a sign of equality between the reasons and causes for their hardships. I hope that we will be able to create the atmosphere of moral catharsis. And to reach that atmosphere, we have to know that the truth albeit subjective category, is the starting assumption. And that is why everything that has been adjudicated, established, has to be a part of our consensus from which we will build on the future of Bosnia and Herzegovina. And it is there where the legacy of the ICTY plays a very important role.
We have a bit more than half an hour for your questions and comments, and I would kindly ask you to stay focused on the topic discussed on the panel 2.
Uključen jesam. Ovako, slušali smo izlaganje.
We have listened attentively to the presentations of the panelists in panel 2. Allow me to make few comments about the media complaining that they are not well informed, that they cannot get to something that is being hidden from them, so they have to make do. But then they also acknowledge that they are under the pressure of certain political agendas. It would be good if they could tell us what political agenda are they talking about. We know that media contributed to the crimes during the war, spreading lies, manipulating people. No one has been prosecuted for that. Mr. Slobodan, the lawyer, you talked. Goran, I apologize. You gave a very nice presentation. I liked every word you said. It's all true. It's exactly as you said it. But again, we are all victims, as you said, each individual. But those who committed crimes, they are also victims of their policies, of their politics that pushed them into committing those crimes. I so regret that there is no mechanism to prosecute people who organized the crimes, who motivated them. Hitler never stood the trial, but fascism did. Fascism stood trial because it tried to annihilate everyone. And the similar situation was here under the pretext of Greater Serbia. It would have been good if people stood trial for that. It would contribute to the reconciliation, to acknowledge that crime. I'm not trying to say that people are criminals, but only those among them who led their people to commit crimes. If maybe Mladić would have been a good person and would have been a good general if there was no policy to push him into doing what he did. Zoran Stanković worked in the cemetery exhuming graves. He sent photographs to some filmmaker who made this terrible movie telling him that all this was done by the Muslims while he was exhumating graves at Kamenica. There are some writers and, of course, some film directors that should do more. Something that we can read, something that we can look at, especially young people, and help them to gain perspective on things. Thank you. I will have to interrupt you because I will have to interrupt future speakers if they are not focused on the topic. So please try to be focused on the topic. I want to greet everyone, especially mothers of Srebrenica and Žepa enclaves. As you can hear, I have a sore throat. Mr. Gabrieli mentioned the residual mechanisms. I did hear something about it. I have some information about those mechanisms. I have a question, though. Since he talked about the archives, and that is the topic of the panel 4. Has this decision been reached in the Security Council, yes or no? And then I will join in the discussion during panel 4. And I want the participants of this conference. This is not a political gathering. If you want to deliver political speeches, you can go to the building across the road, because we all know that victims yearn for justice, and every victim has his own or her own truth. If we're going to discuss individual cases, then we have to go back to 1991 and each year until 1995. Enisa Duratovic, one more question, and then we will give the floor to the panelists to answer. Mirsad Duratovic, president of the Prijedor 92 former camp inmates association. I have a question for all panelists and everyone present here, and I will give a short comment. Do you think that the Hague Tribunal fulfilled its main task to send a message that crime does not pay as a victim of war? And the victims whom I represent, we believe that the ICTY did not fulfill this main task. And now, at the final stage of its operations, we are prone to conclude that crimes do pay. I will try to explain this in few short sentences. For example, there are numerous pieces of evidence in favor of my contention that crime does pay, because these people did what they did during the war, and most of them generated enormous wealth. After the war, in their national circles, they held high-ranking positions, and through those activities, they again garnered a lot of wealth. And if one of them was accused and indicted, he received all the possible material and financial support he could get, and if he is sentenced, he is usually released after serving 2/3 of the sentence and is met by his national circle as a hero and receives the support from his relevant entity. He is given an apartment, his family members get jobs, his children and children of his family members receive scholarships, and I don't know what else. So do you think that the Hague Tribunal fulfilled its main mandate, sending the message that crime does not pay? Is there anyone who would like to go first? Goran? Yes. Does crime pay? I don't think there is justice in this world. There is no justice in this world. There is no justice that would be an equivalent to a grieving mother to people who suffered in detention camps. There is no sentence for that. However, if we don't have this mechanism, which is not perfect, then all criminals would gloat over their victims. We have to move forward. The ICTY has done its share of work. We were unfortunate in being those to whom these things happened, and it is a message to everyone, the United Nations and all those who will establish courts in future for some other geographical locations, I hope never for former Yugoslavia again, to use this experience and be critical in their work, to take what is best and be critical about what proved to be bad. I don't think that crimes pay, in terms that for example, that I was a criminal and now I have 1 million marks in my account. My humanity and my honesty could not be traded. Maybe the crime pays in economic terms, but as a society we have to invest effort that people who committed crimes are perceived as criminals and not as heroes, and that we all have to be honest to ourselves. I agree, Srebrenica is a horrendous crime against Bosniaks, but what happened in Srebrenica is not a model of what happened in the entire country. I was not forced out of my house by the Serbs or people who committed crimes in Srebrenica. I was forced out by the Bosniaks, by members of the army of the Republic of Bijeljina. Should I hate Muslims because of that? Fortunately, that did not take place. I live in Sarajevo, where Muslims are the majority. I am not bothered by the fact that there are hundreds of mosques, because I look at people as human beings. We should look at people as human beings, as not as members of ethnic communities, because it prevents us from seeing a broader perspective that committing a crime is the end of humanity, is when people cease to be human beings. There is no material compensation that for the things that I did to another human being. As a society, we are still not sufficiently aware. We are still looking at each other as Bosniaks, Serbs, Croats, and others, and telling ourselves, I was a victim, not you. At some point, we have to overcome that perspective and look at other people as human beings.
In my view, the ICTY has achieved its main purpose, and I'm just not sure that its main purpose was to send the message that crime doesn't pay off. The ICTY was obviously established to try those found to be the most responsible for what happened in the conflict of the former Yugoslavia. Unfortunately, and I think that's what I tried to say in the beginning of my presentation, it looks like the expectations towards the ICTY were very high and perhaps to a certain degree unreasonable. We've heard a lot today about the need to achieve justice for all victims. I'm all for it, but I just don't think that it is realistic for an international criminal tribunal to be expected to achieve that goal for every individual victim of these horrendous crimes. And this is why there is still some dissatisfaction with the work of the ICTY, but there can be no doubt that the establishment of the ICTY was indeed the beginning of the end of impunity. There is no doubt that had it not been for the ICTY, we wouldn't have seen any of the other international criminal tribunals set up since then to try those crimes. And like the speaker before me, Goran just said, I fully agree. Unfortunately, there is no possible material or other compensation that can compensate victims for their suffering. And certainly the trials conducted by international tribunals or national courts will they will never be able to achieve that goal, which is yet another reason why a mixture of various elements and mechanisms needs to be used to essentially try and turn the page and move on to the future. Just the last question on the archives. Yes, the decision has been taken, and it's very clearly stated in the Security Council's Resolution 1966 that the archives of the ICTY will be collocated with the mechanisms branch that deals with the ICTY, that is in The Hague.
Just a second, what Mirsad just asked, it's very important from the point of view of the victims, because many who have served the sentences, when they rejoined our community, were rehabilitated, even in material and financial sense, which is horrible. We have seen high-ranking officials accepting persons who have served their sentences with greatest honors. And these people should not again be allowed to sit as parliament members, as people representing certain official policies. I think that we have to act together. It is in our own interest that people who committed war crimes can no longer hold any political function, any official function, and unfortunately, that is not the rule prescribed by our electoral law. That is the question that leads us to this conclusion. To this question, does justice exist? We believe in cosmic justice because we believe that what you do comes back. People who lose this sense for justice, who lose this feeling of compassion towards other people, are people who have given up on life. As I can see, you have not given up on life. And we can give the floor to Mrs. Nidžara Ahmetašević, because I think this would be a good opportunity for her to follow up on that. Maybe, but as you know, the organizations working with the victims do not, that the media does not often pay focus to the organizations working with the victims. And what I want to respond is this, to this question whether The Hague fulfilled our expectations. No, it didn't. We expected justice from The Hague. Of course, that is what we expected, because we have seen terrible things happening to us, and that was not a lot to expect. It was what we could expect. In judicial terms, yes, it's important to have The Hague. It's important, the sentences that they rendered and the verdicts they rendered are important, but they did not communicate them properly with the public. We have laws allowing people who were sentenced for war crimes to be candidates during elections. What is more disappointing is that there are people in this country that would vote for them. The Hague did not send this message that people who were sentenced for the most horrible crimes are murderers. Several hundreds and thousands of people across Bosnia and Herzegovina casted votes and voted for murderers who will now hold different functions at the local level. That's not only the case in the Republika Srpska or the Tribunal, etc. The same mistakes are made by the national courts, which are not opened towards the media, and that is accepted by the politicians, so that a group of persons who are indicted for war crimes, specifically the politicians in the Sarajevo canton, decide to give them material support so that they can defend themselves before the court of Bijeljina. I didn't hear any reactions coming from the associations of victims. I did hear some comments from the media. That person that I'm talking about is indicted now, and we should expect, and we want everyone to be treated equally, and we want to hear information so that we know what has been concluded and what has been done. We have one comment here, then Mr. Dukic, and another, Srebrenica Šačir, representing the Association of Camp Inmates in Bosnia and Herzegovina. I will have 3 questions concerning the Hague Tribunal. I would like to say that it did justify its existence, and without it, we wouldn't have the situation as we have today. But I'm asking myself a question, and I'm asking that question of you all and the representatives of the Hague Tribunal, how to ensure that the facts established by the ICTY and the truth proven there, how to make it acceptable for everyone in Bosnia and Herzegovina, make everyone accept it. Until that happens, I don't think there will be any progress made. And another question concerning individual and collective responsibility. I've seen many examples in the past that telling me that we did not move much forward since 2005, 2006. Everything is the same, and I don't know if it will be the same after 2012. You have a man who committed the war crime, but he is celebrated by his ethnic group. He is received as a hero, given money, and people will vote for him again at the elections. As the journalist said, the people who enable that to happen are the worst, because that goes beyond individual responsibility. How can you allow a person who committed a war crime to be a candidate of a political party and receive votes? I need answers to those questions. And the third question, the Hague Tribunal will soon close its doors in 2014. What will happen later? What will happen to the victims? I told Mr. Brammertz the other day when he mentioned the protocol of cooperation between Serbia and Bosnia and Herzegovina, and as long as the victims are against that, and until the mechanisms are introduced in that protocol to ensure that criminals who committed crimes in Bosnia and Herzegovina are prosecuted in Bosnia and Herzegovina, although they are citizens of Serbia. And also, I'm afraid that by signing this protocol without these mechanisms, that we will give mandate to the Republic of Serbia and its judiciary to arrest Bosniaks and Croats in Bosnia and Herzegovina. Thank you.
Thank you. Mr. Dukic and the madam in the second row after him. I apologize for standing up, but I will stand up to say that Serbs should not be compared with Hitler. I originate from a family of partisans. My uncle was a national hero among the 23 monuments in Bosansko Petrovo that are no longer in existence. I will ask this lady not to offend me and my family by comparing Serbs with Hitler. The conflict here was tragic, and those who committed crimes will be held accountable. But you cannot say that Serbs are equal to Hitler. We know where we were and where you were. Thank you. Madam in the second row. My name is Nura Begović. I'm from Association Women of Srebrenica. I come from Srebrenica. I will ask the moderator of this discussion to interrupt every question and comment that is not related to the topic of the discussion. My question is, I'm very interested about what we heard today about the residual mechanism that was presented by the secretary, by the registrar. The 1st of July 2013 was underlined several times as the most important date. Can you tell us more about the work of this mechanism? Where will it be seated? And I think there was another question about this residual mechanism asked before, so can we talk about it more rather than listening to various provocations? We are victims, still searching for the remains of our family members, and we want to know what this mechanism will do. Will there be any statutory changes, or will it follow up on the work of the ICTY? What kind of cooperation will it maintain with the national courts? Can you tell us more about that? Thank you. And the last question for this panel, Mr. Mirsa Tokača, and then we will hear from the panelists. I will be very brief. I don't want this gathering to ignore an essential question raised by Mr. Bulić. And what he said is very important, and it pertains to the use of documents, parts of testimonies of protected witnesses. I will kindly ask representatives of the tribunal to take serious account of what Mr. Bulić has said. If we do not resolve this issue, the entire legacy of the ICTY will be put in question. The use of documents is crucial for us, for the prosecutors, and for the broad public. Can Mr. Bulić tell us about what the prosecutor's office intends to do in this regard? Mr. Bulić, perhaps we can start from you then. I, of course, did not go into details of this issue, and I will not be able to go into details now. But generally speaking, in practice, prosecutors face serious problems with this. When we seek amendments to protective measures for a certain individual who testified before the ICTY, we regularly receive negative response because that person did not accept the revelation of its identity to the court or the prosecutor's office in the given case. Even if it is a key witness for a certain event, without cross-examination of that witness, the transcript is not a piece of evidence that can be the basis for a court verdict. That is a huge problem. And another problem are transcripts from closed sessions. We learn from people who testified that they spoke about certain people. They tell us, I told to The Hague that this person participated in the commission of the crime. But we have no documentary confirmation of that because of lack of access to transcripts of closed sessions. Of course, in certain situations, it is understandable that the ban is placed, but it would be reasonable to grant the prosecutors access to such transcripts. Would you like to add something?
Well, maybe let me start with the last question about the mechanism, and to confirm that the mechanism will have two seats, so to speak. In other words, it will have two branches. One in Arusha for the ICTR, the Tribunal for the former Yugoslavia, and one in The Hague for the ICTY. The Arusha branch has already started. It started on the 1st of July 2012. The ICTY-related branch, the Hague branch, will start on the 1st of July 2013. And the functions that I mentioned earlier, I just don't want to repeat myself at the moment. I think the important message to pass on at this moment is that after the closure of the ICTY, there will be a body, a mechanism, that will enable access to ICTY archives, ICTY evidence, documents that might be necessary, and also the entire case record, as a matter of fact, in all these cases. Requests for assistance will be addressed to that body, and that body will be dealing with such requests for assistance. In other words, this is the Security Council's response to the need to continue with national prosecutions. There will be something that stays behind after the ICTY is closed. Having said that, by no means will that be enough on the path to dealing with the past. As we heard from all the panelists today, judicial proceedings are only one element of this process. And as I was listening to many of the people today, I kept thinking, it's a question of ownership. It is really a question of who has the ownership of this process. And it's my view that it's you. It belongs to you. It cannot be that the ICTY or the future mechanism will do it for Bosnia and Herzegovina. There is only so much that it can do in assisting, essentially, in that process. And a very nice, very good question was asked, how to ensure that the facts established by the ICTY can be accepted in BAH. Well, that's exactly the point. I don't think, I mean, of course, the tribunal could have done better, and definitely we are to blame to a certain degree for not being able to communicate well enough our judgments and the facts established by the tribunal. But at the end of the day, answering this specific question, how to make sure that BIA, the people in Bosnia accept the facts, I think that this is something that no tribunal can reasonably be expected to actually contribute to. Thank you.
Very briefly about how to ensure respect for final decisions. We have to be aware that war crimes trials are not just random trials like petty theft or something. This is something that carries a broader context. A medieval philosopher said people should be forced to do what they don't do if it is for the benefit of the society, and over time they will realize that it is a good thing to do. We had opportunity to pass laws on denial of genocide and so on, but I believe that at this point, because we did not reach this stage in the development that we can accept trials against our own, so to say, then my proposal is to have provisions incorporated in criminal codes where we have similar provisions about a failure to enforce a court decision and so on. I'm sure that the lawmakers in Bosnia and Herzegovina could define a new offense pertaining to questioning of final judicial verdicts or decisions. Thank you for taking part in this discussion, and I will invite you all to lunch. We will resume at 2:30. Thank you.